Canadian justice system. According to Canada's system of justice, Canada's legal system is based on combination of common law and civil law. Common law evolved into a system of rules based on precedent. This is rules that guide judges in making later decisions in similar cases. Civil code contains a comprehensive statement of rules. Many are framed as broad general principles to deal with any dispute that may arise. Canada is a federation, a union of several provinces and territories with a central government, so it has both a federal parliament in Ottawa to make laws for all of Canada and a legislature in each of the 10 provinces and 3 territories that deals with laws in their areas. Laws enacted at either level are called statute, legislation, or acts. When Parliament or a provincial or territorial legislature passes a statute, it takes the place of common law or precedent dealing with the same subject. It was only with the Canadian Charter of Rights and Freedoms that human rights in Canada were protected in the written Constitution. The Constitution says that the Charter takes priority over all other legislation in Canada because it is part of the Supreme Law of Canada. It applies to all government action, meaning to the provincial legislatures and parliament, and to everything done under their authority. Despite of these clear definitions, most judges and especially judges of Supreme Court of Canada ignore the law and legislation and try to use only precedent because they can use it as a magic box to make judgment in their own interest. They don't care that cases are similar or not. They make similar judgments in totally different cases and different judgments in similar cases. Sometimes they have many different and contrary meaning for one simple word. For example, in my case, the Council of Association of Professional Engineers of Ontario referred to precedent cases of Edwards versus Law Society of Upper Canada in 2001 and Cooper versus Hobart also in 2001. While a judge wrote that, quote, "In this case, Mr. Salehi was not someone who suffered loss at the hand of a regulated professional who wanted to claim against the wrongdoer's licensing body. He is a member of class of licensed professionals under the Act. When he applied for his license, the defendant was required by S14 or Section 14 of the Act to issue a license for him if he met the regulatory standards." End of quote. 15 months later, another judge with only 9 months' experience referred my case to Edwards. It was interesting that he had previous judgment in front of him. Even the Supreme Court of Canada referred to cases of Edwards and Coopers in 2017 in the case of Ernest versus Energy Board of Alberta and didn't remember the difference. Another example was in Court of Appeal for Ontario, where for the definition of bad faith, I referred to judgment of Supreme Court of Canada in Finney versus Bureau de Quebec in 2004. The judges of Court of Appeal wrote my definition and their definition contrary to mine in 2 paragraphs in a row, paragraphs 8 and 9. And instead of referring to latest decision of highest court, which was my definition, they refer to a definition of lower court in 2003. I think they didn't understand the difference of these two paragraphs. These are only a few examples that show why judges prefer to mix these concepts and to justify their decisions and write many pages, refer to many cases, no matter that they are similar or not. The only things is important for them is conclusions which must be in their interest. Government and Parliament of Canada respect independence of judicial system, but judges of Supreme Court and lower courts don't respect their independence, interfere in Parliament responsibilities, and by misusing the common law concept, ignore the legislation and even constitutional law, and make law as judges' decision or precedent. Why lawmaking is sole responsibility of Parliament and judges cannot use precedent decisions only when can use precedent decisions only when there is no legislation in that subject.